purpose of the Open and Public Meetings Act is to provide communication between the public and the governing bodies. And the Open and Public Meetings Act provides procedures by which the public bodies, meetings of the public bodies must be conducted. So the Act applies to a public body, and I'm not going to go through the criteria for public bodies. Just take my word for it. The Planning Commission is one of them. The Act applies to a meeting of the public body, and a meeting under the Act is convening a forum for the express purpose of discussing, receiving public comments about, or acting upon a matter. And I put in there the code provisions in case you want to look it up later. There's, of course, much more in the code, more detail, but I'm just, because I know you've had this training before, I'm just going through the highlights of it. If you have questions later on, or you think of something when you get home, just call or email me and I can help you with that. So what is not a meeting? A meeting is not a chance or social meeting. And so it's not subject to the requirements of the Act. But on the other hand, it must not be used to circumvent the Act. And I think this is where a lot of people get in trouble. You've got, Joe and Mary go to dinner with their spouses, and Joe and Mary are on the planning board, and they start talking, and I'm going to vote this way, and I'm going to vote this way too. So when we go in there tomorrow to the meeting, let's make sure we vote that way. You should not be doing that. You can make it up your own mind in your head. Don't talk about it, but you should not be using those opportunities to agree on different things or talk about how you're going to vote in a meeting. So what must be done openly? That would be the information gathering, and as they talked this morning about the surveys, the workshops, set up a booth at the public fair, get people's opinions. Information gathering is public. Formal action is also public. Now, you don't have to do everything in front of the public. Deliberations can be done privately. And so there's this case, Dairy Product Services versus City of Wellsville, which pretty much lays it out. As long as the information obtaining procedures are conducted in the open and any final or formal action is announced or issued in the open, the decision-making or deliberation of a public body during a judicial process, and that's what they consider your deliberations, may be held in private and is exempt from the requirements of the Act. So, in order to have a meeting, as previously described, you need to give notice, and that notice should be given not less than 24 hours before a meeting. The notice should include the agenda, date, time, and place. The notice must be posted, and it needs to be put in 3 places: at the principal office of the Commission, on the Utah Public Notice website, and they also have the website in the code, and you probably know where it is anyways, and provided either to a newspaper or a local media correspondent. Now, previously you had to publish it in the newspaper. Now they just say you have to provide it. Whether the newspaper wants to publish it or the local media correspondent wants to talk about it on TV or whatever they do, that's up to them. It's not your problem anymore once you've provided it to them. So what else must be posted? The annual meeting schedule. You must give annual notice of your meeting. So if you meet the 3rd Tuesday of every month, in January, you post a schedule. We meet the 3rd Tuesday of every month, and here are all the 3rd Tuesdays, and here's what time we meet. Yes?
So for those delivering that to the media correspondent or newspaper, if they want to feed the public side and you simply say no, the fact that you provided it, like a news release,
I don't know about how the fee issue plays within that. I don't know. Yes.
There are some requirements for, hearings have to be posted in papers for certain types of things, depending on what your county ordinance says and then the state code says. But for administrative dealings, as far as I understand it, it's just basically an FYI is how we go to the local correspondent.
Okay.
And then that holds you responsible if they opt to post it. For example, the standard examiner they actually pull it off of the state website and they post that every Sunday as a courtesy. And
Yes.
They don't charge the local entities for doing that. It's just a courtesy that they do. They cannot charge the local entities for doing that. So-
And my understanding, a lot of them did that. Johnny, do you know anything about that?
Well, what I know is that, as it was discussed again this year at the legislature, one of the biggest lobbyists, obviously, in this area are the press.
Yeah.
And whenever it comes to these notice issues, the press wants to be able to require that the local entity to have to notice it in the newspaper and have to pay a fee for it. Because let's face it, that's what they run their business on. They're not selling newspapers anymore now that the iReaders have come out. So they lobby very strongly for you to have to continue to put notices in their newspapers and have to pay for it. So if you're in a situation where you think you're not going to pay them for it, but you need to have the notice, get with your county attorney if they're not sure. A real expert would be Adam Troop at UAC, follows that really closely and would have the most up-to-date information on what's going on right now and what might be the law next year as they lobby. Okay?
And I was just thinking, maybe that's why they put it in as a provision. You just have to provide it to them. You don't have to make them publish it, whether it's, you can't make them unless you pay a fee or whatever. But you're right, Adam would be the person to talk to about that. Okay, so we also need to, besides the annual meeting schedule, emergency meetings. The notice requirement, that's a 24-hour one, does not apply as long as the commission gives the best notice practicable. And an emergency meeting may not be held unless the commission attempts to notify all commission members and the majority of the commission members approve holding a meeting. Do you have very many emergency meetings? That would be no. Okay.
Emergency zone.
Yes. Well, if they change it, I don't think they made, the change has gone into effect yet. And frankly, last night I was looking online trying to find where because I've heard that something's been changed. Yeah, and I couldn't find it and I apologize. I didn't get much notice to prepare. All right, I had a day. Yeah, an emergency meeting here. Okay, so your agenda has to be specific, and you must provide reasonable specificity to notify the public as to the topics to be considered, and you should list each topic under an item on the agenda. None of this block topic stuff, but just number them out so people can understand what you're going to talk about. And you can't take a final action until the topic is listed under an agenda item. It's included in the advance public notice, which also includes emergency meetings. And topics not listed on the agenda may be discussed only if raised in the meeting. No final action may be taken on that issue, and a subsequent meeting with the item properly listed on the agenda must be held. And that's set forth in the case Ward versus Richfield City. An open meeting, and I don't know who thought this up, a meeting is open to the public unless closed pursuant to the act, so okay. An open meeting includes a workshop or an executive session in which a quorum is present unless closed in accordance with the act. Now, do you have a lot of closed meetings? No, okay. Well, if you have a closed meeting, you can read through yourself, that's the purpose of the closed meeting. And if there's any time you want to close a meeting, you should definitely talk to your county attorney and make sure it's okay. Because the purpose of closing a meeting to discuss these sorts of things is usually done by the governing body, not the planning commission. You need to record your meetings. Written minutes and audio or audio-video recordings. The recording must be complete and unedited, properly labeled and identified, so when somebody sues you in 2 years, you can go back and find the recording to show what you actually talked about in the meeting. And I've run into, as a lawyer for defending counties in different situations, I've run into this issue. Yeah, we recorded it. Well, where is it? Well, I think it's on Sam's computer somewhere, or good records weren't kept because nobody thinks at that time that they're going to be sued or what they decided at some particular meeting is going to be called into question down the road. You just never know. So you always need to be prepared, and you'll be glad you did, trust me. Written minutes are only adequate if the meeting is a site visit or a traveling tour and no votes taken. Written minutes are the official record of action taken at the meeting, and so the commission must establish and implement procedures for the approval of the written minutes of each meeting, and must make arrangements to retain the written minutes permanently. The minutes need to include date, time, and place, names of commission members present and absent, the substance of the matters proposed, discussed, or decided, and that includes public comment. If somebody stands up in the meeting and talks about, a proposed ordinance or something like that, you need to record, Jane Doe got up and talked about this, and, maybe a sentence or two on what she said. You also need to keep a record of each vote, and the name of the person that goes back to the public who stands up and provides the testimony or comments in a public meeting. Violations, just don't. And so what can happen is any final action taken in violation of the act is voidable by a court. But the person only has 90 days to start their lawsuit, which means they have to jump on the notice of claim filing immediately, and then of course they have 60 days before they can file a lawsuit. Usually they're not quick enough and don't bother to read the statute, so it's probably safe in that respect. But the court may not void a final action for failure to post on the Utah Public Notice website, which we talked about before with the agenda item, if the failure is due basically to internet technology. My system went down, whatever. And people have tried to do that. You didn't post a notice on the public website, so we can void that action. It just doesn't work that way. But just be aware these are pitfalls that can happen. The Attorney General and county attorneys shall enforce the act. And we're talking about the Open Meetings Act. The person denied a right under the act may sue to compel compliance, enjoin a violation, or determine the act's applicability to discussions or decisions. A commission member who knowingly, intentionally violates a bet or advises a violation is guilty of a Class B misdemeanor. There's a knowing and intentionally, so they have to show that you knowingly and intentionally violated it. So if you negligently violated or just weren't sure and made a mistake, that's not going to be a Class B misdemeanor. And that's it. Any questions? See, you guys?
I have a
Excellent.
question.
Oh, okay.
I'm sorry. Going back to not a meeting, you talk about deliberations may be done privately. I've never been aware of that. Can you explain that further?
Well, I'm thinking of a particular county, and it's probably the same with all counties. They have budget. Okay, so their budget process. They have a public meeting. They post it. Anybody can come to it. And they put on there, okay, at 10 o'clock we're going to discuss the budget for the Justice Court. At 10:30 we're going to discuss the budget for the Assessor's Office. And so they have it posted publicly, and that's the information gathering phase. So the commissioners are in there talking to the department heads that show up and any public that shows up and gather information. So that's your public gathering of information. After those meetings, they will meet in their offices. They won't call an official meeting, but they might sit around a table and discuss, okay, how are we going to make this budget work? What are we going to do? Look at these figures. And they have discussions among themselves. They might talk on the phone. They might talk with the county attorney. That's the part that can be done in private. They're simply discussing. They're not getting together saying, okay, we're voting this way on the budget when it gets to the public hearing again. And that's the best way I can describe it. So when the budget comes up for a vote, well, first they post it and everybody gets a month to comment, a tentative budget, and then they fine tune it again and then post the final budget and vote on it in a meeting, open meeting. So the deliberation part is basic, and it might be helpful if you read that case, the Wellsville case, because I think that sets it. There's more paragraphs in there that explain it. better as to what constitutes the deliberations that can be done in private. But it's not a case of where you can go and everyone agree, okay, when we go out in that in that public meeting with the public out there, this is how we're all gonna vote. That's something that should not be discussed or done as part of your deliberations. It's basically tossing around ideas, tossing around the information. How does this work? How do you understand it? And then making your vote public when you go out into the public meeting.
But if you have a 7-member planning commission, or 2 commissioners on that planning commission get together, they can decide how they want to vote. There's 2 of them, there's not a quorum, so can't those 2 sit and discuss it and talk about it?
They can discuss it.
And decide, no, I don't think this is a good idea, that, as long as there's not a quorum, they can. You have a 5-member, you can have only 2 people get together, 7 members.
Mhm. Yes.
I think it's dangerous simply saying, well, if it's doing with the budget, it's okay, but if it's dealing with a public application, it's not. So, you know, I think that it kind of set a double standard there by saying certain deliberations are okay to be done in private. You know,
That's what the court said. I mean,
Yeah.
how else do the members of the board, even like commissioners, how do they talk? You know, you can't just operate in a vacuum, and that's what the courts recognize. You go to your office, you know, you don't do everything in front of the public. You don't sit there and argue about stuff or, I don't.
we did.
Well, I guess you can, but
We
this is,
tried, we threw things at each other, yeah. It was brutal.
that must have been really.
Yeah, it was good recording, so, yeah.
Some of that goes to the question again of the differentiation between administrative role and legislative role.
Oh, this was on, you know, when I was on council, but yeah, we firmly believe as much in sunlight as possible,
Yeah.
so, yeah.
The amount of sunlight that needs to be shown when you're doing administration is very high.
Yeah.
Legislatively, there's a little bit more room
Yeah.
for deliberation outside of the public view, but the decision-making has to be done.
Yep.
There is one other piece here that kind of ties in but isn't in the Open Public Meetings Act. There was a change to the Records Keeping Act this year, and I'll look it up while Brent's doing his presentation, but the timeline for getting your minutes ready and available to the public was shortened up considerably this year, and the time period for you to have them approved was shortened up as well, so you may need to have your meetings more often to have your committee actually approve the minutes within the new time period. I think it's 45 days that you have to have the minutes approved, and like 3 days to have the minutes written and available for the public. So, sorry, but speak to your legislature. Don't shoot the messenger. Any other questions for Kathy?
Did you say 3 or 30?
I think it's 3 days to have.
3 days in draft form.
The draft form.
So my question is regarding public hearings and noticing public hearings. State code says 10 days before the first public hearing. But in the typical land use form, a lot of these hearings go to the planning commission, and that's the first meeting.
Mhm.
And then they go to the county council, that's the second, or it could be a second meeting, or a subsequent meeting. Which one is the one that needs to be noticed 10 days in advance? Both of them, or just the one with planning?
I think it's both.
Okay.
Because the-
I don't think it's clear, but do both.
Yeah,
You know, be safe.
Right.
yeah.
Yeah, be safe, because that's the source of contention. You didn't put it on the minutes, and you didn't post them on time, and I'm suing you. And frankly, we got 3 lawsuits with this kind of claimant right now.
Would it be fair to provide, instead of that 10-day notice, just in the agenda, which comes out 7 days, for the second meeting for the county council, that this is a continuation of a previously noticed item? I'm just trying to eliminate some of the resources that go into noticing,
Yeah.
and maybe that's not.
Well, in this, and what we're talking about by notices, you give notice by publishing the agenda. Now with the zoning, there's an additional notice that you give before you publish the agenda, correct? Is that what you're
Yeah,
saying?
because there may be notice requirements that are required
In
elsewhere in the
addition.
statute because of your changing the zoning. You know, you're gonna
There's a
rezone.
new zoning, notice statute that was passed this year to make it, you have to do even more notice than before.
Yeah, So, but these notice provisions are separate, so you're gonna have to look at which one is the more oppressive on you, of course, and go that direction.
Okay. Thanks.
It's gonna be the recommendation you get from the guy that pays the claim when you do it wrong. But your county attorney is gonna be your best bet for answering that question, because, first of all, then you've got him signing off on it, and second of all, you know, the county may have their own standards that they want to comply with, and they want your committee to follow the same standards that they're using with other committees that they have throughout the county for elected officials.
Thank you.
I think there's a differentiation between public meetings and public hearings, timeframe requirements.
Yes.
So you need to check into that, because public meetings do not require as much timeframe as public hearings.
Yeah. Just so that you understand what a public meeting is, and are having public meetings that aren't public. So that's what we're going to try to talk about. Again, the act provides for individual penalties and individual sanctions that no one can help you out with. The fact that they're going to have a file or give you a fine as an individual for intentionally violating the act, or taking you out of your appointed position, taking you off the planning commission. There's nothing that we or the county or anyone else can do for you. This is what we're doing. If you want to continue on the